in bail matter, 17 years in custody. The rate of appeal of the year 2022.
Your Lordship, direct of the matter may be listed. I have filed 3 memos. Your Lordship has fixed a date. Any date matter next to any date. Increment is there. And we matter. I have annexed the copy of the
Another matter, review petition not assigned to any other division bench.
Supplemental list. Item number 1.
In this case, on the last occasion, Your Lordship has been pleased to. But faithfully, Your Lordship found that whether everything by the proposing authority has been brought to the notice of detaining authority while passing this order of detention by the detaining authority. I have taken instruction on that. In fact, the proposing authority has brought all the 8 cases before the detaining authority, but the detaining authority has taken cognizance of 3 cases that is related to NDPS matter. In that respect, if this Honorable Court directs, I can bring out the proposal.
No question. Close the argument. Whatever you want to place, please.
Madam.
No, additional affidavit is being filed. What you have stated here?
Here. Not in the additional affidavit, I have stated the first, my contention, that is in paragraph 6. I've specifically stated that the rate petition that has been filed by the petitioner.
Paragraph number 6.
Yes, paragraph 6 starts from page 1 here also.
Yeah.
Page number 2, I have highlighted 3 points on the count where the petitioner has challenged the order of detention and the order of the advisory body.
Please read it what very well.
Yes. The present deponent files this affidavit in order to bring forth certain documents.
You have given a copy to Mr. Katkia?
Yes, ma'am. To opinion 1 and 2, opinion 4 and 5, and the my learned senior for the petition.
Yes.
The present deponent filed this additional affidavit in order to bring forth certain documents which are relevant for time consideration of the Honorable Court for due adjudication of the case. It is a matter of fact that such documents have already been placed before the detaining authority as well as served upon the petitioner. However, the petitioner has never raised those contents in the writ petition and has filed the petition solely on allegations that. Now I have pointed out all the 3 contents that is made by the petitioner. The order of detention is an outcome of malicious move of the sponsoring authority and the detaining authority without applying its mind has been biased with the report of the sponsoring authority, and accordingly such order of detention has been passed which inflict upon the petitioner. The next ground is the advisory body which should have been referred with the matter within 5 weeks from the date of detention has not been complied with the provisions of the Act. Hence, on the ground of technical limitation, the petitioner should be given the benefit of passing the order of detention dated 23/7/2024 and the order of confirmation that is on 18/10/2024. The third point of challenge, Your Lordship, the advisory board is required to submit its report within 11 weeks from the date of detention of the person concerned. However, in the present case, the advisory board has passed the order of confirmation on 18/10/2024, which should have been 8/10/2024 as per the petition. Now, Lord, these are the only 3 points on the basis of which this writ application has been filed. Pursuant to that, we filed the counter affidavit. In the counter affidavit by 4 and 5, as well as 1 and 2, and opposite by the 3, the present opposite party. The present opposite party has taken a stand in the case that there are other cases also pursuant to which has been referred to by the proposing authority to the detaining authority, and considering all the cases, because the other cases were two cases were of Bihar and Orissa Excise Act, one case of IPC, and other three cases of IPC.
Is it your case that beyond the ground he has taken the writ petition, he can't take any other grounds?
No.
Even
Yes.
if you say something in the recounter?
No, they have taken a ground, the petitioner is taking a ground at this juncture that had all these cases would have been brought to the notice of detaining, whether the detaining authority taken cognizance of all the cases or not, whether it has been brought before the other cases or not. Because we have taken a stand in the counter affidavit that he is a habitual offender since last 20 years. That has been a point of concern of this honorable court. This honorable court has been pleased to ask me that
You
when
see, in the grounds of detention,
Madam.
which you have served on him,
Madam.
you have stated that we have taken into account three cases. Those are all NDPS Act cases.
Madam.
Commercial quantity of ganja seized.
Not
So on that basis, he submitted the representation. He was not aware that apart from these three cases, any other cases were taken into account by the detaining authority.
Lordship,
Please wait.
please, madam.
Have patience. When you filed the counter affidavit, you said that we passed the detention order not only because of those three cases, but also other 5 cases that those are pending between 2000 to 2022. So it was on the basis of 8 cases you passed the detention order. But what you informed to the petitioner is that 3 cases were pending against you, and on the basis of these 3 cases, we are passing the detention order. So when your mind, you have taken the decision on the basis of 8 cases, whether you are required to supply all those information to the petitioner as detainee or not. That is the crux of the matter.
Before the petitioner was detained or arrested pursuant to the detention order, the seizure list was made on 26 2024 that contains all the 5 cases, as well as when the order of bail was passed by this honorable court, it was.
You have not stated in your counter affidavit
Madam.
that even though 8 cases are pending against him, but on the basis of these 3 cases, we took the decision of ground of detention. You said that on the basis of 8 cases, we took the decision that there should be preventive detention of the petitioner. So when you took the decision on the basis of 8 cases, you should have informed the petitioner so that he could have filed the representation.
It has been.
You have not done, Mr. Counsel. Your ground of detention mentions only 3 cases.
Yes,
Not even stated that there are other cases pending against you. Not a single line is there. So whatever was there before the detaining authority or the sponsoring authority for subjective satisfaction, all those materials are required to be supplied to the detainee.
That is being supplied when it was
You are now neither you have taken on that day in the counter affidavit, nor you made a submission on that day when this point was raised by the petitioner during course of argument. Perhaps in this affidavit, additional affidavit, you have taken that ground.
Yes, I have taken that ground.
Yes.
May kindly see paragraph.
So is it not an afterthought story?
It was brought to his notice on 26.
On what basis we can know? On what documents we can know?
The Panchanama is there also in 26 seizure on the 68F. That is also there on it.
Please, argue.
No, you just simply answer one question, whether what made the mind up to the detaining authority to pass the detention order, whether it is 8 cases pertaining to 2005 to 24, or it is 3 cases.
It is only 3 cases. I have clarified.
But in the counter, you have said you have taken into consideration the conduct of this accused for 2005 to 2024, and there are 8 cases. So that made the mind up for the detaining authority to pass the detention order. And therefore, The ground of detention should have contained all these things. So he could have, you have prevented him from giving a representation, right representation to the board.
Before representation,
That's the issue.
Before representation, it has been intimated. On 4/8/2024, that has when it's annexed to C/3. It has been intimated to him. The Panchnama is there, as well as he has signed on all the pages where it has been intimated to him. That's why I filed this additional affidavit. You will also may kindly see annexed to B/3. Annexed to C/3, you will also may kindly see. There we have already intimated. Page 32, you will also. All the cases. My only some contention before this honorable court is we have presented all the eight referred all the cases.
Is this a part of ground of detention?
No, it is not, because
Then
that is because only refer to NDPS cases.
these are very simple things. Don't waste time.
No,
Very
Your
simple
Lordship,
thing.
only if my lord permits, I can give one example myself.
You may consider whatever, but it should form part of the grounds of detention.
My lord,
If it is not form part of the ground of detention, you have prevented him from giving right representation to the board.
penal provisions are on a different act.
Then the detention order goes.
NDPS often
As simple as that.
Whatever not there, you cannot just at a belated stage say that yes, law requires this. We have been asked by the honorable judges. The
No, not
petitioner has also raised the question. So let
because
us
that was the
clarify
contention.
why we have an additional.
No, it was the
Within the-
contention of the petition. On the basis of that, I am filing this affidavit. It's not from the honorable court, because the petitioner has contended that that's why I am answering this.
Yes, anything else?
What I mean to say, you also may kindly allow me one thing that comes to my mind with your permission, my lord.
Yes.
Suppose a person is caught within the forest area for theft or anything, whatever. For forest offenses.
You must understand, you are
Yes,
not
forest
arguing a
offences.
bail application. You are arguing a preventive detention.
My lord,
Liberty of a
what
person.
I am trying to only say differentiate
All
is
these things, analogy,
because
logically, or
NDPS
this thing will not work in a
Madam.
detention case.
my only contest is NDPS authorities could not have exercised their power or authority under the Bihar and Orissa Excise Act or the IPC. So they have confined themselves, though it was referred to them. And what I mean to only intended to by the opposite partner 3 to say or 1 and 2 to say is that all the cases shows the criminal antecedent, and he was well aware of the cases because the cases are age old. But we have taken cognizance on the basis of detaining authorities taken cognizance on the basis of 3 cases of detaining only. This
All right,
NDPS.
that's all.
Madam.
Yes, Mr. Patkin. You are Mr. S.S. Kashyap.
Not sir.
You are appearing for whom?
Opinion number 3, because initially I filed the counter now going to
So who are
I learned
appearing
here
for
is-
the other opposite
run
parties?
a TSJ. I have filed counter all 3 of them.
Just a minute, let us be clear. Government of India, Joint Secretary to Government of India, the counter affidavit has been filed. 1 and 2. Huh?
That is at flag C.
Okay, 1 and 2 at flag C. So this is appearing, who is Deputy Solicitor General? of
Mine.
India?
Filed the counter.
That is, I am appearing in the witnessing for both NCB and Joint Secretary. We are appearing for all.
1 and 2. Then just a minute. Let us see that again. 3 are you. State is there, and 5 is also state.
Yes.
So 4 and 5. State, Mr. 1, 2, 7.
We are for 1, 2, and 3 are.
And 5.
The judgment of we sometimes try to find out.
Just 1 minute.
This is incomplete judgment. Where is para 3?
No, the thing actually assisted
Para 3 is there.
was also
That's the relevant para.
para 2 is important.
But relevant para is
No,
3.
is it
Yes.
not the complete decision?
No.
No, it's a judgment, but from the net I could only this was
Wait a moment, sir. 24 4 SCC
and paragraph 2 year
Supreme
also.
Court cases
Exactly.
131. एटा आपण SCC ऑनलाइन नहीं ना
Next, it's I don't know why.
Para 3, the first is counter affidavit disclosing the ground in addition to those disclosing to detainee held right of effective representation is affected. Constitution shows Mishra. It first. She'll cover the para 3 is there.
ये ठीक है बात करने से हम नो हम तो हम system seriously online or do make it find by citation. Preferred site on receipt get citation paper site first देखा जाओगी 1974 site
पूरे मौत को देखिए
wait let's see our in site our in but 19 now we come to this that side that is 4 now we go to this side 131 plus 80 click करो थोड़ा get this addition full page नहीं effort हाँ सीधा करो
para 3 चल
कोई 3 years ना अरे so उसे तो para 3 ही सीधा नहीं
8 click 8
effort click करो हाँ सीधा click करो
it out relay
এয়ারপোর্টটা পারাত্রি অবাক subsequently হচ্ছে therefore there is violation of both article 22(5) of the Constitution of India and section 3 of the Act. In this view, we are constrained to pass the detention order on the prisoner and direct his release. Last line.
Yeah, equivalent have you seen? Equivalent? Equivalent have you seen? Air equivalent?
Air
Air
I am not very fine.
1974?
Sassi Kettur versus State of West Bengal.
74.
Sassi Kettur.
Supreme Court 525.
बाद में
There 1974 Supreme Court 5-5.
Five to five.
5-5. Six online setting up.
ठीक है judgment is settled. Yes, any other decision?
Nonetheless, I have got given all the judgments. I am just Amina Begum, the recent judgment of the Honorable Appellate Court for the State of Telangana.
ଦେଇଥିଲେ ସେଦିନ
They this is a paragraph mentioned to this. That a strong view has been taken by the Honorable Appellate Court regarding this preventive detention. And even to the extent the Honorable Appellate Court has stated that
citation memo कौन है कोटा दी चुके हैं
plus 4 I have already given. 1 Rameshwar Shaw also I have given.
yes
And 3 also I have given. 5 Amina Begum. 2023 9 SCC 587. Para 17, 21, 22, 38 and 43. There must a view has been taken by the Honorable Appellate Court that even if it was held by the Honorable Appellate Court earlier, that it is not justiciable, but with the passage of time, with the changing of law, now it is very much justiciable when a person's precious personal liberty is being
you
curtailed.
have given which paragraph are relevant in that
Yes,
you
I have mentioned the paragraph.
all right
And so far as here malice in law and fraud and power that I have relied upon S.R. Venkatraman for Singh of India, para 5. Because malice in law doesn't mean that the person should carry ill feeling towards the, detainee. Even if with good faith or with bona fide interest, he has taken a decision which is illegal, that also comes in the purview of fraud and power. That is 1979 volume 2 SCC 491 para 5. And also in Mohinder Singh Gill versus Chief Election Commissioner 1978 1 SCC 405 at para 8 also the same thing has been stated. This is on administrative law.
this Mahinder Singh Gill case
Yes, sir.
you have not mentioned which paragraph
Para 8 plus I have stated.
no you see in your citation that Lee memo
yes.
you have given
I sorry, I had not stated.
if you have given please give it once again
Yes,
so that
I'll give
referring
it.
we find that in all other cases paragraphs have been indicated except that Mahinder Singh Gill case
Yes, that is para 8 on administrative law. And so also, I will give the paragraph.
ତାଦେହରେ ଲେଖିଦିଅ ନାଇଁ ତା ଦେହରେ ଖାଲି ଲେଖିଦିଅ ରାହୁଲ ଲେଖିଦିଅ ତ ରାହୁଲ ସେଇ ଯୋଉ ମହେନ୍ଦ୍ର ସିଂ ଗିଲ୍ କେସ୍ ଟା ଦେଇଛନ୍ତି ଆଇଟମ ନମ୍ବର ସିରିଏଲ ନମ୍ବର 8 ରେ ତାର ହଉଛି ପାରାଗ୍ରାଫ କେତେ
Paragraph 8. So what permit me, then I can place it.
place it
This is regarding administrative action.
Yes, administrative law is also applicable here. Because when an administrative authority is on the basis of a statutory power, is exercising that particular power, is expected to exercise the said power in accordance with the power prescribed as such. So it is that.
have you
And para 8 I am reading.
Mr. Patkia
Yes.
have you find out any case under this particular act this prevention of illicit traffic in narcotic drugs and psychotropic substances
I could not.
section 3 of the
Exactly on this point I could not get, but some cases on P10 Act are there, but of other high courts. But exactly not on this point.
not on this point
Regarding, if subsequently a ground has been taken, what has not been informed to the detainee at the time of submission of grounds of detention, then that itself invalidates the detention order. On that basis, I have not got any. Even our High Court doesn't have any
okay
judgment.
you have received the now today that affidavit which has been filed
Yes.
do you want to say anything on that
Plus, on that affidavit, it is plus with you respect what I am submit, and is an afterthought. Already your lordship has appreciated.
no not appreciated I just told
Yes,
him
minus. And the other aspect I am making to
don't take our view we may change our view
minus.
you whatever you want to say
That is plus they have referred some cases. That is Gochapada case number or page 14.
No, this is all, but whether you want to file anything on that particular
sir,
affidavit,
not
you
necessary.
don't
Because
want. All right, that because we will, while mentioning in the judgment, we'll
Yes.
say that the
Milos,
That
in
you
course
have
of
stated that-
argument, because when the matter has been kept parted, one additional affidavit is being filed.
it's all right, but we just put you at that whether you want intend to file anything, we'll mention that you said no. Okay,
My submission is it is an afterthought and has been filed during the course of argument, and only to justify the latches on the part of the detaining authority and so on the sponsoring authority.
okay. Yes, State Council, anything you want to say?
No, my lord. In our part, we have we are only the jail authority only kept the accused in the jail custody, and they have produced the accused before the advisory board, and they have forwarded the representation of the detainee to the authority. This was the duty of the.
Okay. Where is Mr. Pari? You want to say something or we'll close the other? Mr. Pari?
Technical glitch, Your Lordship.
No, we just want to, he just in the, during course of argument, he certainly put us something, but whether you want to add anything or not, that just we want to say before okay, there is no
He is
necessity.
representing for union affiliate, he is representing for state.
Right, what they told you, she କହିଲେ ଗୋଟେ କଣ ମୁଁ ଆମେ we represent a 1 and 2.
You are representing for union affiliate, all.
All three have filed the counter.
All.
No, you said that you are appearing for opposite party number 3.
For all three, I filed the counter because that CDC now, because my learned senior is appearing for 1 and 2, I am arguing on OP number 3. Because the additional
exactly.
time is.
So not just we wanted to ask him that whether he wants to say something or we like
The very statement of the OP number 1 and 2 that with the assistance of OP number 3, they are filing the affidavit.
the lecture then close hard further argument. So the land council senior planning council Kashyap files that additional affidavit matter, which is taken on record. Copy of the same has been served on the land council for the petitioner in court as well as on the land council for the state. We put a pertinent question to the Mr. Katkia, land council for the petitioner, whether you want to file anything on the additional affidavit which has been filed today by Mr. Kashyap. The answer was in the negative. Judgment placed by the land council for the petition. Argument judgment is on. Yeah.
Item 2.
There are two cases. In this case. Two cases, one is punishment or disciplinary proceeding has been challenged. Another is entry in the CCR. Representation having been rejected.
The pleadings are complete.
Pleadings are complete. Counter has been filed. If my lordship will agree, we can proceed today. I am ready with the date chart. No,
Prepare some time.
No, you have filed your counter.
Yes, counter.
So what further you want to file any rejoinder or?
Not required, I can
Not-
proceed.
Only in the next sitting, Lordship, I prepare. Is that major penalty, the penalty is in important. So I have to prepare, get a preparation to address this one.
Maybe permitted
No, no.
just.
Why not start today?
Yes.
For some time,
Yes.
then
That's right.
we can make it.
But unless I convey that, but this is the preparation, otherwise start. That's why I've been conveyed. Let
Let us get a fair idea about what
Let
it
us get an idea about.
Yes,
what
then your mind learning changes.
can be. So which matter will argue? You will
First
start
one.
with the first one.
you are going to argue in sub item.
No, yeah,
First item,
it's
first
about the first item. Before I.
Mr. Pari is there. Mr. Pari?
Yeah, my lord, sorry, my lord.
No, no, it's all right. That item we reserved for judgment because we just wanted
yes,
to ask you that whether you want to say something on that matter or not.
My lord, only
Not-
technical is that apart from 3 out of 8, it is within the knowledge of the all the forums. It may be taken conjointly. In the time of passing on, that much I am on to submit. Nothing more, my lord.
Okay, okay. You are appearing for OP 1 and 2.
1 and 2, and NCB Mr. Kashyap is there.
All right.
Oblige.
Who are the opposite parties in this case?
Opposite party, the state of Orissa registered of this court.
All total 4 opposite parties.
Four opposite
So
parties.
3 are registers and 1 is
Yes.
state of.
Yes.
And you are to argue for all the opposite parties. 1 to 4.
2 to 4.
Then who is appear who will argue for one?
Counter has been filed for 2 to 4.
No, no.
For state.
State अपन argument करिए ना आउट ऑफ दिया
I have to take instruction from the The counter is for 2 to 4.
No, it's all right.
State is a formal party. It's a formal party.
So
Yeah, only two.
that is Aurobindo Maharti. Yes.
Yes.
Mr. Raushad, please.
No, though I have prepared the note of submissions and a exhaustive date of events, but I have prepared for today's purpose a very small date chart, which are the admitted fact. Then I'll take your receipt to the relevant subject. 1/15/12/2010, the petitioner joined judicial service and appointed as additional district judge, Barampur, pursuant to selection list dated 4/9/2010. That is annexure 1 at page 15. 15/12/2015, the petitioner was given selection grade scale of pay pursuant to notification dated 29/6/2016. That is annexure 2. 5/8/2017, pursuant to the notification dated 8/8/2017, the petitioner was promoted to super time scale. Then on 5/6/2020, the petitioner joined as a Registrar General of this honorable. On 5/4/2021, the Honorable High Court of Orissa, through its Registrar General, issued a show cause notice 5/4/2001 to the present petitioner on the ground that present petitioner, while working as a Registrar General of this honorable court, has acted upon an unsigned order and registered a suo motu report. That is annexure 4 at page 16. The present 12/4/2021, the present petitioner submitted a reply to preliminary show cause notice, that is annexure 5. 9/9/2021, suo motu writ petition number so and so registered by the present petitioner was disposed of by 3-judge bench headed by the Honorable Chief Justice and inquiring authority and the second judge of the division bench as member. 9/11/2021, memorandum of charge issued to the petitioner under Rule 15 of CCA rule with article of charges, statement of imputation of misconduct, and memo of evidence. That is Annexure 7. The 9/12/2021, the present petitioner submitted a written note of defense and accordingly inquiry was conducted. The 9/9/2022, a so-called notice was issued to the present petitioner along with the inquiry report dated 3/9/2022, and the petitioner was asked to submit the representation on filing of court. Then 26/9/2022, the petitioner submitted a representation for filing of the inquiry of the inquiry report. Then 3/11/2022, the petitioner was asked to submit a representation against the proposed penalty. On 14/11/2022, the present petitioner submitted a representation against the proposed penalty. Then on 21/12/2022, present petitioner was awarded with a major penalty by reducing the grade of the petitioner to the selection grade, and it was also clarified that upon reduction, the pay of the petitioner at the initial scale of selection grade, with further stipulation that the next higher grade with super time scale will be considered after 5 years. That is the impugned order at Annexure 22. Then 16/2/2023, in pursuant to this, the refixation of the scale of pay of the petitioner pursuant to the order of council. Now I take it straightly to the brief. These are all admitted facts. I'm just stressing. Then I'll take whatever the controversy is there and thereafter. Then also kindly come to page 59. Page 59. Annexure 3. This is the crux of the matter. While the petitioner was acting as a Registrar General of this honorable court,
Where are you pressing, Mr.?
page 59, Annexure 3.
Yes.
Registrar General. You also see, this is the note sheet. The Honorable Division Bench of the Honorable Justice S. Panda, Kumari S. Panda, and Honorable Justice Swami Justice Pani by order dated order number 1 dated 24/2021 has observed as follows. The Odisha Reservation of Post of Service for Socially and Educationally Backward Classes Act 2008 regarding reservation of SCBC category has already been quashed by this court in the judgment dated 29/6/2017. SCBC category is still going on in respect of advertisement issued by the state government, public sector undertaking, and even by this court. In the meantime, 4 years have already passed. No further legislation was made by the state government as stated above, and it is a continuous cause of action, and the state functionaries are violating the court's order. Since it came to the knowledge of the court that the said reservation is still continuing without taking further step by the government, this court initiated so motu proceeding, impleading the state government as well as the registered judicial of this court as opposite parties, and engaged B. Rautrai and senior advocate, Mr. Manoranjan Mahathir and senior advocate, Ashok Kumar Mahathir and senior advocate as amicus curiae to argue the matter. The name of the learned amicus curiae be reflected in the brief as well as the cause list. Issue notice to the opposite party, that the Chief Secretary, Government of Orissa, Bhubaneswar, Principal Secretary, General Administration Department, Government of Orissa, Bhubaneswar, Registered Judicial, Orissa High Court. Then additional government advocates shall accept notice on behalf of the Registered Judicial Orissa High Court, Cuttack, and shall file counter on his behalf. Counter be filed by the opposite parties by 15th March 2021. Next line, you also kindly mark. In this connection, the copy of the order dated 24/2/2021 placed at flag A may kindly be perused. It is pertinent to mention here there is no nomenclature as so motu proceeding. Hence, in view of the kind order of the honorable court dated 24/2/2021, a so motu writ petition may perhaps be initiated, citing the registered administration of the petitioner and impleading the Chief Secretary, Government of Orissa, Bhubaneswar, Principal Secretary, General Administration Department, Government of Orissa, Bhubaneswar, and Registered Judicial High Court of Orissa as opposite party. Place for favor for kind consideration and order. Deputy Registrar Judicial, yes, place this one on 26/2/2021. Also kind mark. And this note sheet says, in this connection, the copy of the order dated 24/2/2021 placed at flag A. That order is at page 60. Let's look to that. And that order, page 60, which has been quoted in the note sheet, that is 24/2/2021. Let's get it. And the same thing, which has already quoted in the note sheet, that order. But if you also look to page 61, this is an unsigned order, which was placed before by the deputy registrar in the note sheet, and the registered judicial in charge at that time, in fact, he had endorsed it to the deputy registrar to place it along with this order before the petitioner. Petitioner was the registered administrator, the registrar general at the relevant time. You also kindly mark, this order was enclosed with the note sheet, and this order is an unsigned one. And you also at this juncture kindly come to page 62.
In the 59 at the end, whose signature is this?
Yes.
Approved.
That the deputy registrar signed it, and approved by
The corner. Approved.
approved. That
Whose
means
signature?
but we have that is the approval is by the petitioner.
By the petition.
Yes.
This is petitioner.
That is the crux of the matter. That's it. So he being the because registered judicial was the opposite party in that application, it was by the order of the registered general in charge, registered judicial in charge, was placed before that. But this order along with the this note sheet was placed, and in fact the petitioner, there is no denial, petitioner approved it with all bona fide that this is the order. That is what. Then you also kindly come to page 62, where the problem starts. Annexure 4, page 62. After about 3.5 months, this so-called notice was issued confidentially to the petitioner by the Registrar General on 5/4/2021. Let's get it.
Yes.
Yes, sir. This is 5/4. Let's look to the sir. I have been directed by the Honorable Chief Justice. But this direction of the Honorable Chief Justice is 4/4/2021, that is at page 85. But now I am not going to that. But by the order of the Honorable Chief Justice, to seek written explanation from you in the matter of registration of a suo motu writ petition number 7943 of 2021, during your tenure as a Registrar General. Copies of the document enclosed with this letter reveal that the said writ petition was registered on 26/2/2021 on the basis of an unsigned judicial order dated 24th, on the basis of an unsigned judicial order dated 24/2/2021, under your instruction / approval as the then Registrar General of the court. I am further directed to request you send to me within 7 days from the date of the receipt of this letter in writing all the facts within your knowledge and explain why and under what circumstances the said suo motu writ petition came to be registered. What are the enclosure? 1. The unsigned order dictated by the Honorable Justice Respondent. 2. The dissenting undersigned order. I'll show that has been enclosed to this. The dissenting undersigned order of the Honorable Justice Panigari. And 3. The consequential order recording the difference of opinion and stating that the matter is required to be heard by third judge, which is also unsigned. Yes. The unsigned order dictated by Honorable Justice Panda, having the endorsement of DR Judicial of Dr. P.M. Sama, the then Registered Judicial in charge, with the date 26/2/2021, while forwarding the same to the Deputy Registered Judicial. C. Note prepared by the Deputy Registered Judicial, Mr. Janmejaya Das, duly approved by the then Registrar General, Sri Malaya Ranjan petition, date on 26/3/2021. Then B. The first page of the registration sheet and the filing acknowledgement slip of suo motu writ petition civil number so and so, Register Administration Orissa High Court versus so and so, bearing the endorsement of the person to whom copies thereof. The letter sent to Mr. Manohar Mahanti by the Deputy Registrar Judicial containing the endorsement of receipt of the said order, because these 3 senior counsel were engaged as amicus. Then you also kindly come to page 64. Next page. This page 64, the very same order which has been quoted on signed order, but here it will be different. This has also been enclosed along with that explanation letter from me. People also will see that the opinion, the difference of opinion that is at recent view, that at page 65, that is there. Well, the also look to the first order is Madam Ponda, then S.K. Pani. The suo motu proceeding initiated by my learned sister in the aforementioned paragraph does not make it the fit case for going ahead with such a proceeding, especially when the subject matter is pending for the Supreme Court of India, right? Especially petition number so and so, arising out of the judgment and order dated 26/9/2017, passed in WPC number so and so by this court. Since the subject matter of the above mentioned so much proceeding is subjected is sub judice, the instant proceeding is wholly unwarranted and smacks an unnecessary temptation of crossing into the territory of executive function. The court must act with the concussion.
Where are you placing Mr. Rao?
That's it.
65.
Page 65. Page 65.
65.
Yes,
So this order was communicated.
Yes.
but this was not there in the.
Yes, no,
earlier.
that is the point, exactly the point. That is exactly the point. The first note sheet which was placed on 26/2, the copy of the order is unsigned order.
And the name of both the judges were there.
The name of both the judges were there. Order was pronounced in the open court. That is also no dispute. Order was pronounced in the open court, but that is not a matter at the present. But that unsigned order was communicated, it was placed before the petitioner by the deputy registrar judicial, along with the note sheet, extracting the order of the honorable. This is the order, this is the copy of the order, and petitioner signed.
The dissenting view was not placed.
Dissenting view was
Not placed before it.
not.
Whether
Dissent-
whether the dissenting view was there by that time.
No,
It was not
that
even.
was not there. I can't go to that extent, but
वो statement कुछ और भी
you also rightly, you also asked that question rightly. That is the
Relating of
and why we have also the you know asked that why you have immediately signed. You can also look to page 65. That order also
20
we are
24 to 2021
yes
was a Friday.
26 to 24.
22 2000.
24 to 24 to this was the 26 to it this has been signed on 26 to
Order
Order dated.
oh, I see. Oh, acha, acha. देख.
Appears to be the same day, but in different, but the original order is required.
ठीक है, just that.
Yes. Yes, sir. Go ahead.
Sir, it was a Wednesday. It is a Wednesday. It
Wednesday.
was a Wednesday.
Okay.
Of course, Mr. Mahanti, myself, both were also appointed engaged as a amicus curiae, along with Mr. Manmohan Mahanti. And that's it.
Yes, sir.
That is
And
besides the point, that is why you are not submitting now. Otherwise, we are privy to whatever happened in
This,
the court.
no, Mr. Mahanti, Mr. Rao sir, just want to ask you that on 24th to 2021, when this order was passed, whether both of you were present in that court
Yes,
or
yes.
in your absence?
Very much.
we both are present.
So that is the reason you
We are
have been appointed as
amicus
amicus.
curiae. We are in different cases. We are there.
So you
All that in this.
You were there in the courtroom.
Yes, we are in the court. That is a fact. Order was
Because
followed.
it matter pertains to reservation, then the court requested us to assist.
Yeah, that's all.
That's now you also kindly come to now you also got the point.
So this dissenting thing was not even dictated by the honorable judge in the open
No,
court on that day.
no,
Because nothing happened.
no.
And this date is 24 to 2021, and this was placed before the petitioner on
26.
26.
Yes.
Right.
So it presupposes that by 26 also there was no dissenting note.
Yes. Yes.
That
And
is why
that order itself shows that we are required to send it also see the order. That order itself it shows
we send
that
a
copy of this order be supplied to non-senior advocate engaged as amicus curiae by 26 to 2021.
Hmm.
So therefore, on that day, that was placed before the petitioner on 26 to 2021.
As a amicus curiae, have you got any order on
Sir,
26?
No,
we have not got.
Which order
We
you
both
got?
have not got. Mr. Manoranjan Mahanti has got.
Which order? The first one they got.
24th order.
Yes,
24th order.
24th,
24th, the first order
24th.
signed by both the judges.
Yes.
Not the
No, not
descending.
signed by.
No, not signed by.
Not signed.
But descending view
No,
Had
no,
gone
descending
obviously.
there was no-
If descending is obviously
No, no.
it's separate.
At least if it would have been descending view, then the question of appointing us
no, not
arise.
doesn't arise. You are right. Absolutely.
That is why I told it is little bit embarrassing for us to state what really
Anyway,
happened in
that's
the
I
court.
don't know,
No, but if that was not there,
Sure.
then how this order number 2 was passed on that day? Order number 2, 66. That is also same date.
Yes, sir.
How it
In
came?
view of the above difference, that is also a point, sir. That I was exactly asking, but something has happened, I can't. But it has been done such.
No. If it has been done subsequently, then
Well, the very fact that a draft was placed before the petitioner. Conceived from the colonial. The draft was initially, the DR placed that file before the registered judicial. And since he was a party, he refused. The petitioner was not even concerned about this matter. Then, because he was the senior-most man, then the DR placed that
No,
matter.
Mr. Mahadi, please answer it. See this order number.
I've seen him.
We are putting a question to you.
How can we know, Milord?
No. Just a minute. Because
যদি
dissenting order
ସେଇଥିଲା
ସେଇଦିନ
ସେଇଦିନ କେମିତି ଅର୍ଡରଟା ହେଲା
ସେଇଦିନ ନହେଲା
ହଁ,
ତାହେଲେ
କେମିତି ହେଲା?
ଅର୍ଡର ନମ୍ବର 2 ଟା କେମିତି 24/2/2021
Same day.
ଏବଂ ସାଇନ ଏଇଟା ସାଇନ ହେଇଛି ନା ନାଇଁ?
ଏଇଟା I don't know.
ଅର୍ଡର ନମ୍ବର 2
ଅର୍ଡର ନମ୍ବର 2 ବି
so motor proceeding record ଟା ଦେଖି ସାଇନ ହେଇଛି. Have you got that record?
No, that's why I am placing out this. Once there is a difference in order to same date, so original order equal to
that is also on site. That is also on
No,
site.
you have not produced the record.
No, that's it is recorded because on this
And record to be
same
produced.
date
Yes,
the order has been passed.
You see,
Whether one
record
is
to be
signed or
produced
not
in
signed,
sealed cover.
The
And
honorable court has directed to
Yes.
produce the record.
you have to produce this record in sealed cover, not in this way. Also, what we put a question to, please think over it. You say that on 24/2021, the matter was taken by a division bench, right? So in the open court, the order was passed. On that day, one of the judge, let us say, dictated the order, and the other judge in open court did not pass any dissenting order, right? Dissenting.
Not to our knowledge. That
All right, it's all right. But on that day, another order comes up, that is order number 2.
That is obviously after
May I be permitted? Can you also
And that is also very same day.
same day?
That is most important. So, and that if that is signed by both the honorable
That
judges,
is on site. That is on
then
site.
how you say that
that I don't know whether it was signed.
No, it is not- it is on site.
From the order, it is apparent
the
that
second one,
SB
order
is there.
number 2 was also unsigned?
Site. That this has been supplied to us by them.
Have you filed the certified copy of this order in this proceeding?
No.
Because you have the scanned
the
copy
record, sir,
doesn't
please
bear the
direct me.
signature of the
No.
judges.
Sir, exactly what is the petitioner
Where from
person
they
that
got
we are
it?
page 74? So I say look to page 74, that is the explanation of the petitioner. That will reflect everything. Kindly come.
How did you get this order?
They have supplied along with the show cards?
Unsigned one.
Yes. That one was placed before me, the first one.
Then
That
the-
was also supplied to me.
That order was unsigned. This is also
This
unsigned.
on site. This
Everything
is
is
exactly what you have just directed you have produced. Can you also look to page 74? This is exactly the petitioner's reply. Immediately after, thereafter. Also look to that. I should place people also. Page 74, annexure 5. In reply to the show cause notice. This is the explanation.
Annexure?
Page 74, annexure 5. ठीक है. Hard copy. May I place
74.
74? This is the explanation offered to the
First copy. They all speculation. There's something last one is not the code. They do immediate.
Focus, have you explained about
Yes,
this
yes,
order
yes.
number 2?
I have absolutely just tried that. Transfer, page 74.
75, huh?
74.
74.
Now, this is the entire case. I cannot either improve or whatever he has said at relevant time.
Yes.
Explanation the matter of registration of suo motu WPC number 1. Sir, in obedience to the direction of the Honorable and with profound respect, I humbly beg to submit my explanation herein below regarding all the facts within my knowledge and as to under what circumstances the above referred suo motu petition came to be registered. On 26/2/2021, at around 6:30 p.m., the Deputy Registrar Judicial of the Honorable Court placed a note sheet before me and urged to approve the same in order to comply the order of the one division bench of the Honorable Court on the ground that the compliance of the order was to be done on that day itself, and the same could not be done unless a case was registered. Since the type of matter
Compliance means serving the copy
serving
on the
copy of the
amicus.
yes, on 26 2.
Right.
Since the type of the matter does not come to the undersigned, on my query, the Deputy Registrar Judicial clarified that as the registered judicial was directed to be arraigned as an opposite party, the matter was not put up before him as was being usually done in this type of matters. In the note sheet, he had quoted the relevant portion of the order and also informed that as per the direction, copy of the order was to be supplied to the learned senior advocate engaged as amicus curiae by 26/2/2021. That is, on the day it was put up before me for approval. He also urged that the brief along with the order was to be supplied to the amicus curiae on the same date, and thus it is required immediate registration for compliance of the order. I approved the note sheet by oversight under the impression that the file was in order. Adding to my misfortune, the Deputy Registrar Judicial did not brief me that he had placed the note sheet basing on an unsigned order as at enclosure B of your kind letter. And even I could not focus my attention on this part of the order. On good faith and with the honest intention to comply the order of the Honorable Court in promptitude, I approved the same, which as an inadvertent mistake in my part. I may humbly submit that since the note sheet along with the order was put up before me by a competent officer of the registry, I even could not sense that there was dissenting opinion of one of the honorable judge of the bench. The note sheet was placed before me after 2 days of the date of the order, and also the same did not contain that part of dissenting order. Quote, I may further humbly submit that Deputy Registrar Judicial of the Honorable Court reported that he took instruction from the Honorable Judge presiding the Honorable Bench that registered administration of the Honorable Court would be petitioner, as I was skeptical about such fact as to whether the registered administration could be petitioner in a case where the registered judicial was directed to be one of the opposite party before approval of the note sheet. I sought instruction over phone from the Honorable Judge presiding the bench regarding this aspect, to which her ladyship is instructed to put registered administration as petitioner, and for any changes, if required subsequently, the Honorable Bench would take care upon hearing the parties. At that time, her ladyship did not inform me about the dissenting opinion of other Honorable Judge of Bench over the matter, and that the said order was on unsigned one. I may humbly submit here that if at that point of time I could focus my attention that the order was not signed, or it could come to my knowledge that there was dissenting views of one of the honorable judges of the bench, instead of approving note sheet, I would have definitely and instantly applied the same to the Honorable Chief Justice for seeking his lordship kind instruction in the matter. Under the bona fide impression that the same was merely about the registration of the suo motu proceeding based on a judicial order, I did not feel it proper to bother the Honorable Chief Justice in this matter and cursed the bad law. Cursed with bad law. I routinely approved the note sheet on good faith. The same was an error of judgment on my part, being persuaded by an honest intention of compliance of the routine judicial order of the Honorable Court, which was placed in the last hour of the day, 5 p.m. When I was almost exhausted. I may further humbly submit that since the date of my joining in this judicial department, I have always discharged my duties. That's it.
Then he did two things. One is he acted upon the note put before him.
Right.
Secondly, he cross-verified from the Honorable Chief Justice regarding this, and she got instruction. These are the two things he did.
And after this, you also look to the charge sheet. The entire thing is this is the charge sheet, that page 82.
82.
Yes. Gross misconduct. That is the main. That is the only allegation. So therefore, I have prepared with certain judgment to be cited to your assets that this cannot be constituted as a misconduct at all. I'll show you. We also look to page 82. Whereas so-and-so, during your incumbency as
Gross misconduct, dereliction of duty, administrative indiscipline.
So far, the failure to maintain absolute integrity and honesty, that has been exonerated. That has been exonerated.
And found guilty on gross misconduct.
Yes. Failure to maintain absolute integrity and honesty, that has been exonerated. And these three, you also look what is the allegation. One, that is the only allegation. That you, while working as a Registrar General, High Court of Orissa on 26 February 2021, without making the Chief Justice informed, approved a note of the Deputy Registrar Judicial and thereby instructed for registration of a suo motu proceeding on the basis of an unsigned order bearing dated 24/2/2021, purported to be of the division bench of the Honorable Justice so. Though you had no authority under the rules of High Court of Orissa 1948 to issue such instructions. Then two, that your instruction and approval for registration of the suo motu proceeding so that you had acted on a validly signed judicial order passed by a division bench of the court, though in fact there was no such signed order available in the record. You being a judicial officer even failed to appreciate that an unsigned order carrying direction for registration of suo motu proceeding was not to be acted upon without the approval of the Chief Justice. That on the basis of your instruction and approval, the registry of the High Court registered a suo motu case number so and so and sent notices to the opposite party enclosing copies of above unsigned order. Office of the Advocate General Orissa received the notice, and a copy of such notice was also received by the Office of one amicus curiae, Mr. Manoranjan Mahathi. Next is that the above act load the majesty of the High Court and the amounts to gross misconduct, dereliction of duty, and administrative discipline. Thereby, it failed to maintain absolute.
When it says that the Office of Advocate General received it and Mr. Manoranjan Mahathi received it, they've received the first order or the second order?
Yes, they can say. But I know that only the
That assume relevancy in this.
first order. First that order.
First order.
And sir, and the punishment was awarded. You also look to that. That is not case. And the more important, you also look to page 85. Everything has been done by the then Honorable Chief Justice. But the Honorable Chief Justice in every stage of the proceeding has some action, some role to play. And you also know that those judgments, I brought those judgments, even the judicial officer case also, that is not permission. You also look to page 85. That is there, that copy has not been supplied to me. And another thing you also carry in mind, if that division bench matter was referred to a larger bench, three bench. The Honorable Chief Justice, the then Honorable Chief Justice, the Honorable Judge who was the inquiring officer, second judge, and third judge who was descending. And after that was dropped, that proceeding was dropped. Then this proceeding was allowed to continue. And one of the judges, Honorable Judges, was also appointed as the inquiring officer. All humility, I have no other observe. So then you also kindly come to what is the punishment has been awarded, what punishment. And another thing also carry in mind, those that the registrar judicial who is in charge and the deputy registrar, one is completely exonerated, super the registrar judicial, and deputy registrar very minor penalty of one. And so far as I am concerned, also look to page 185, the punishment. I am reading page 185, annexure 22. The court on consideration. The court on consideration of all the materials on record in DP case number so and so initiated against the Manoranjan Das, ex-Registrar General, High Court of Orissa, Cuttack, at present presiding officer, Industrial Tribunal, Raurkela, and his representation dated so and so, have been pleased to observe that the misconduct of Sri Das, a senior judicial officer holding an important position of trust, responsibility, and confidence in the organizational hierarchy of the High Court cannot be condoned. Accordingly, the court are pleased to award Sri Das with a major penalty of reduction to a lower grade, that is selection grade, SG, in the same rank of district judge as envisaged in sub-rule 6 of Rule 13 of the OCS and SCCA Rule 1962. It is clarified that upon reduction to the lower grade of selection grade, the pay of Sri Das will be fixed at the initial scale of selection grade with entitlement to annual increment in the selection grade. His upgradation to the next higher grade in the super time scale will be considered after 5 years. This is contrary to the rule, CCA rule. CCA rule doesn't provide such a punishment, but they have invoked the power of the CCA rule. So at this juncture, since your lordship, look sub judgment, 2-3 judgment, I have prepared that.
That is on proportionality.
No, I have made some issues I myself have formulated. Of course, that is all my name. These are all judgment. I'll show only two paragraph. That's for your sake. I have formulated these points.
Before that, can you just take us to the inquiry officer's report?
Yes, I'll take it.
That,
Certainly, certainly I'll take it.
the factual
Yes,
position
Your
should be clarified.
Yes,
Then
yes.
we'll go to judgment.
I was expecting, yes,
Ah.
Your Honor, kindly.
Then we'll see the legal position.
Yes, yes.
Let us understand the factual
Yes,
scenario.
yes. Your Honor, straightway come to page
120
Report of the
inquiry officer.
yes. If Your Honor, look to what page 127, I'll take your certain portion of the main finding, which ultimately, according to me, that is not borne out from the charge itself. If Your Honor, look to paragraph 11 at page 133.
130?
133.
Yes.
Let me read that. You also have already gone through the charges which have been framed against me. I'm reading paragraph 11. It needs to be mentioned at the outset that none of the delinquent officers have ever whispered anything about intimating the Chief Justice on Exhibit 5 or such discussion made with Justice S. Ponda or the instruction given by her to them till 2nd March 2021 when he came to know about the same from the other source. The Chief Justice, in terms of the provisions of the rule of the High Court of Orissa, is the administrative head of the High Court of the court, and the entire registry is supposed to act upon his direction on administrative side. Next slide. The guideline for functioning of each officer of the registry have been issued from time to time prescribing their duties. Despite all such rules and guidelines, neither Janmejoy Das nor Malaranjan Das, in the capacity of Deputy Registrar Judicial and Registrar General, respectively, did not think it proper to bring such an unusual fact of initiation of suo motu proceeding based upon a plain unsigned document under Exhibit 5. Usually, suo motu writ petition is initiated by the order of the Chief Justice or bench consisting of the Chief Justice as one member. This was not the part of the charges. As stated by Department Witness number so and so with the registered judicial of the court, no such precedence is there. No such precedence is there where a suo motu proceeding was initiated by a bench other than the Chief Justice. The sad part of this issue is that the Chief Justice, the sad part of the issue is that the Chief Justice, despite being the administrative head of the institution, was deliberately kept unaware of all such action taken by the officers of registry in such a serious matter where suo motu writ proceeding was initiated based on an unsigned document purportedly issued by one of the division bench, and notice to the Chief Secretary and Principal Secretary of the Government of Orissa was issued. And not only that, but the Register Judicial of the court was also issued with notice. That too, Registrar Administration was arrayed as the petitioner. Department Witness number 1. I mark this. This is the only witness on behalf from the department. Department Witness number 1. The present Registrar Judicial had worked for a long tenure in the court in the capacity of Deputy Registrar Judicial as well as in his present post. He has specifically said that in the initiation of a suo motu proceeding by a division bench other than the Chief Justice is itself an unusual fact, and therefore it is incumbent upon the officers of the registry to bring the same to the immediate attention of the Chief Justice. Admittedly, none of the delinquent officers being the key register, none of the delinquent officers being the key registers of the court did not even attempt to bring it to the notice of the Chief Justice. The Registrar General and Deputy Registrar, though think it proper to discuss with Justice S. Ponda, but did not feel it appropriate to bring it to the kind notice of the Chief Justice. And he came to know that all such facts from the other source. The delinquent officer did not even claim that it was within the knowledge of the Chief Justice when they want on the acting upon Exhibit 5. In such attempt of delinquent officer to avoid the Chief Justice was deliberate or intentional? Question mark. The innocence on the part of Dr. Pavitra Mohan Samal can be understood as he was the in charge registrar judicial on that particular day only, and his action is limited to the extent of marking Exhibit 5 to the register, to the Deputy Registrar Judicial. But the action taken on the part of Sri Janmejoy Das, the Deputy Registrar, and Sri Malaranjan Das in taking instruction and approving note for further action of issuance of notice to government authorities, keeping the Chief Justice in that are certainly deliberate and amounting to administration indiscipline, dereliction of duty, as well as the gross misconduct. This is not in the charge at all.
But what was the penalty given to Janmejay Das?
Only one increment, one increment to cumulative. That's and so far the
And then everything boils down to one thing. That is, you have not intimated this thing to Chief Justice. Everything boils down to one.
That is only 26-2. That's the only thing I approved it. I concede that I approved.
Everything
But
is
it's all gone up.
admitted. Everything is admitted.
Yes.
The only
Everything,
thing is
it
you
is.
should have placed it before the Honorable
Because
Chief
can
Justice.
constitute human error.
That's the
Hypo clock 26-2 exhausted
6:30.
6:30. Now then can I take your lordship to submit judgment?
Exhaustive. You are exhausted in the 6:30. Then that is not ground.
That is not cannot. But may I just 2-3 judgment I cite your lordship? What is misconduct? And whether these issues are sufficient or not, that is for your lordship to accept or not. But we have discussed and formulated this.
Can I be excused?
There's some problem because of okay.
No, Mr. Rauter, we can let
Yes.
him bring the
Record.
record and we'll take up this matter next week.
Yeah.
Which date would be convenient? It maybe next Friday it would be.
But Friday is already any day that your lordship likes except Monday. Monday I have to go.
No, not this Monday, not this Monday.
Any day Wednesday also keep it Wednesday.
नहीं बेंच टा ब्रेक कर यू on a regular bench टा Friday ले किसी असुविधा नहीं break bench as such.
Yes.
We are passing the order to keep this particular record, original record of this Somoto.
Petition registration of the
WPC 7943/2021.
Mr. Buddhadev Gautner, senior advocate for the petitioner in WPC number 8874 of 2023. Mr. Ashok Mahanti, that senior advocate for the petitioner in WPC number 288 of 73 of 2023. Mr. Aurobindo Mahanti, and additional standing counsel for the opposite parties. Mr. P.K. Roth, also with P.K. Roth, then the land counsel for the petitioner plays the list of dates as well as citations which are taken on record. Hearing the matter for some time, we feel it necessary that all the original records in which are connected to this writ petitions kept ready in sealed cover by the Land and State Council for perusal as and when required.
Council appearing for the High Court.
Land Council appearing for the High Court. That is opposite parties number 224. Sealed cover for perusal as and when required during course of argument. So, matter being listed on 7th of February 2025. It will be taken over 10:30.
All humility, but a note is put up. Order is attached. Original file can not the
We would like to see the rules also. What is the procedure to be followed in so many cases?
No, there is nothing we checked up as far as possible. We don't know if there is an internal circular or not. We don't know.
He will address that.
Right.
10th.
7th of
Seventh.
February 2025. at 10:30.